Hi guys, welcome back. One of the best pieces of advice that I could possibly give you is to gather evidence of your employer's discriminatory behavior before you raise a complaint about it. Because once that complaint is on the record, chances are your employer is going to make it harder for you to get it. But having our evidence early doesn't mean that we need to reveal it early. And that's because EEOC cases are proven in stages. The kinds of evidence we need and how much of it we have to show change as we move through the process. If we don't understand that early on, we risk making some common mistakes that can bite us. For instance, oversharing too early in the process can lock us into innocent misstatements that we make, and it gives our employer a chance to twist those into a defense and use them against us. Or oversharing can even make us look too sensitive, which can hit our credibility. We risk front-loading evidence before EEOC needs it, which can make it less impactful and even cause it to be overlooked later in the process when it's really needed. And most of all, sharing all our evidence and showing all our cards too early in the process does a big favor for our employer, one that I'm sure they're not going to be returning. So I want to walk through the basic stages of the EEOC process and talk about what kinds of evidence and how much of it we need to show at each stage, and also talk a little bit about the kinds of evidence that we might want to save for later in the process. And this is based on my experience and EEOC's own guidance in their Management Directive 110. In the federal sector, the first stage of the process is EEOC counseling, and this sort of doubles as our initial interview. I say that because the first time I ever spoke to anyone at EEOC about my case was during EEOC counseling. And at this stage, the counselor is really only interested in answering one question, and that's whether we have enough evidence to show a reasonable person that the illegal discrimination that we're alleging could have happened. That's it. And that's the lowest possible standard of proof that we have to meet in this process. And to meet it, we basically have to show evidence that satisfies the prima facie elements for each of our claims, which generally are that we're covered by one of the laws that EEOC administers, that our employer took some adverse action against us that harmed us in some way, and that that action was somehow related to our protected status or activity. Of course, the exact prima facie elements that we have to prove do vary for different kinds of cases. For example, what we have to prove to establish a prima facie case of retaliation is different than what we have to prove to establish a prima facie case for failure to accommodate, for example. So I put together this table that lays out the prima facie elements for some of the most common claims, and I've made some simple suggestions for how to prove each one. And if you're interested in this kind of information, check the description for a link to download it. EEOC essentially uses the prima facie elements as a sort of checklist to decide if our claim is plausible. But once we've established our prima facie case, our employer does have a chance to provide a legitimate non-discriminatory reason for what they did, and they don't have to prove that it's the actual reason they did it. They just have to show that it's a plausible reason. And once they do that, of course, we have a chance to rebut that by showing evidence that suggests maybe that wasn't the real reason. Now, one of the common things that employers claim at this stage is that we had performance or conduct issues, and that's why they took the adverse action against us. And we can easily rebut those kinds of claims just by showing performance appraisals, emails, or other write-ups that show our performance was actually acceptable. And once we make it through the counseling stage, our case advances to the investigation phase. Now here, I think a lot of us go into an EEOC investigation expecting it to be like the police investigations we see on TV shows. We think our investigator is going to come in, dig through all the evidence, figure out that our employer is lying, and point the finger at him. But that's not what EEOC investigators are there to do. They're there to gather all the evidence and assemble it into a complete and unbiased record of the facts around our claims. And that's about it. They don't determine credibility or motives, and they don't decide who's lying. Those kinds of things can only be decided later in court. Now, the law requires us to be transparent and truthful with our investigator about the facts surrounding our case. And I've seen a lot of people take that to mean that they should hand over every note they ever scribbled, every email they ever wrote, or every recording they ever made. But in truth, we don't have to give up everything we have in the investigation, and actually, I wouldn't recommend doing that. Being transparent and truthful doesn't mean that we can't also be strategic. There are certain kinds of evidence that we may have that could be very useful later on in our case that don't directly apply to our discrimination claims. And those are the things that we could and should hang on to. Things like personal notes or notes about our legal strategy, copies of our legal research, emails to our union or to attorneys. These are considered work products, and we're allowed to keep them private. Detailed medical or mental health records. If we have a disability case, we have to give our investigator enough information to show that we have a covered condition and that we made a valid request for reasonable accommodation. But very detailed letters from our therapist or information about diagnoses that aren't related to our request for accommodation, while they may be useful later on in helping us establish damages, I personally would make my employer ask for them later in discovery. Because handing over too much of this kind of highly personal information too early in the process just gives your employer more time to think about how they can spend that and use it against you. Another thing we may want to keep to ourselves is rebuttal evidence for a pretext that our employer doesn't raise during the investigation. For example, in my case, my boss had accused me of being AWOL and having performance problems many times before my investigation started, and I had gathered documentation to rebut those accusations. But during the investigation itself, my employer never mentioned those accusations, so neither did I. I held on to the rebuttal evidence, though, and was able to use it when my employer did bring those accusations up later in court. Now, obviously, if your employer tries to spin pretext during the investigation, then it's a good idea to give your investigator evidence to show that it's pretext. But you don't have to empty your whole magazine. Keep the evidence you give up specific to the pretext your employer is trying to spin. And in general, I'd be cautious about giving up anything that I wasn't specifically asked for during my investigation. If you need it to prove that the discrimination happened, or if they're asking you for something specific, then obviously you're going to want to hand that over. But otherwise, you may want to think twice about volunteering it. Now, there are a couple of other stages of the process that we need to talk about as well, discovery and our hearing, but we're running a little short on time today, so I'm going to save those for the next video, where we're going to talk about things like the sorts of discovery you can expect your employer to request and how we can try to push back on some of those requests, the kinds of discovery that we need to request from them, and also some strategies for maximizing the impact of our evidence during our hearing. So I'll see you guys for that in a couple weeks. That'll be right around Christmas. Next week, check back for a community post, and I'll see you guys in the next one. Till then, you guys take care.